Department of Insurance and say, we further recommend that the state bar support right, and just take out the extra space before support.
And I think we want to take out programs after HCAs.
So Dana, as amended, is this work for you since you're the one accepting the amendment?
Yes, I accept it.
Okay. And Julianne, was there anything further you wish to say? I see your hand is still up.
Oh, no, I'm sorry.
No, it's all right. Carolyn?
Yeah, I didn't know where to put this in because we jumped in on the resolution pretty quick, but I just wanted to add that the New York group that's considering the same kind of thing is looking at licensing social workers. And so I mentioned this, but I didn't think it was important enough to be part of the report. I just wanted to say that I thought that was a great idea, looking at licensed social workers. So I just wanted to point that out to the group.
Agreed. Any other comment about this before we take a vote on it? Okay, then Linda, could you take the vote, please?
Do we have a second?
Oh, good point.
I will second.
And I see that Amos's hand is raised.
I would just like to suggest we might open it up for public comment before we vote.
I did, or I thought I just did that. I thought I asked, does anyone have any comments before we vote?
I know I meant for public comments.
Oh, okay. Let's see if, let me go to the attendees. I see that an individual named Loretta Sudi has her hand up. I don't know whether it's in regards to this, but we could certainly ask her.
Ms. Sudi, did you want to comment on this resolution?
Oh, no, thank you. I must have put my hand up without realizing it.
All right, thank you.
Thank you.
Okay, so with that, Carolyn, your hand is still up. Do you need to say something before we take a vote? Okay, so I don't see any further hands. Linda, why don't you go ahead and take the vote?
Okay, and was that was Sharon you seconded? Is that right?
Yeah.
Indeed.
Okay. Ashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Sorry, yes.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer. Oh, maybe Sharon. I don't know if Kim had to leave. McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Yes.
Sarouche,
Yes.
Spiro,
Yes.
Torres Ambriz. I don't believe Claudia has joined us.
No,
Judge Wiley
Judge Wiley is off for a little while. She's not here at this moment.
and Judge Yu.
Yes. Thank you, Linda.
Okay, the motion carries.
And Leah, did you want to do general civil before we go to employment?
Yes, I think we should do that. Do you want to go back to the slides, and Linda, and then Carolyn, you are the chair, so of course it's your prerogative as to whether or not you want to present. I know that you don't actually agree with the recommendations, any of the recommendations that came out of the subcommittee. So I'm not sure if you're comfortable presenting. If you would like me to, another option perhaps would be Steve Fleischman.
Yeah, I think it might be better for someone else to do it. Where's Steve? Or you, Leah? And then I'll just talk about why I didn't agree at the end.
I'm happy to do it.
Okay, so why don't you go ahead, Steve? Linda, are you going to put up? We just, I think, made one slide or a couple slides.
So the main issue under the heading of consumer debt is there's a tremendous volume in limited jurisdiction of basically banks and collection agencies suing taking defaults of the individual debtors and no representation among the debtors. We've been told the default rate is as high as 95% or higher. I don't know if that's anecdotal or not, but I have no reason to doubt it. And I think Justice Petro said it was consistent with her recollection, but I don't want to speak for Justice Petro. So the question is, would adding paraprofessionals help somehow in getting that default rate down so people have representation in these cases? I personally think that's a very close issue because, as the Justice Gap study shows, 2/3 of the people who have reported problems don't make any attempt to find an attorney. Nonetheless, speaking for myself, I was persuaded by Greg and Erica that the status quo isn't exactly acceptable either. So, depending on what analogy you want to use, I voted yes to allow consumer debt to be in the program, either with my fingers crossed or holding my nose. I'll let you guys decide which one. But with limitations, we thought it should be limited to limited jurisdiction. It should be limited to representation of individual debtors. Banks and collection agencies don't need lower cost debt. And sort of using the nurse practitioner model, we thought substantive motions would be too complicated and besides are hardly ever filed in limited jurisdiction. So things like summary judgment motions and anti-SLAPP motions would be out. When it came to in-court representation, we agreed with the default that jury trials should be out, and we agreed that bench trials should be out. The only thing I would change on this, I saw the recommendation in housing that I liked a lot about recommending mandatory settlement conferences. If I could change one thing, it would be that, but I don't want to open that up for extended debate. The other area we considered was the area of creditor harassment, which is covered by a myriad of federal statutes and is incredibly complicated. And essentially, we decided to exclude all litigation related to that, but that there were pre-litigation matters that could be done, including cease and desist letters and so-called prove-up letters, which are, prove to me that I owe this debt. We also thought pre-litigation negotiation of settlements probably wasn't even the practice of law anyway, so we could include that in the program. So that's kind of where we came down at the end of the day. Carolyn, do you want to be heard on why you disagree?
Okay, all right. And I've given this a ton of thought and some sleepless nights, because I do agree that the Justice Gap study does, and in real life experience, walking down the halls of the courtrooms in Los Angeles County, that there is a real need for something here in the Justice Gap. And I voted for some of these things, and we've been 10 months working on these areas and excluding things and considering them. However, we had 4 different propositions that we presented on in January and discussed. One was limited, there were, I'm trying to remember all 4. No in court, limited helping with forms, a little bit more in court assisting answering judges' questions, sort of the Washington model, and then full in court representation. We spent about an hour or maybe 2 hours discussing that topic. And then we had a vote on it, spending perhaps another hour. I was given a chance to present my position on no in-court representation at about 5 minutes. So, when we came down to March and we all voted on full representation in court, that really sort of sent something in my gut and in my brain that said, wait. This is an issue that goes far deeper and should have been discussed throughout our subject matter considerations. We knew about it, we talked about it a little bit, but it really wasn't the scope of what we really thought through. And you can see that in this PowerPoint, which you're going to compare and contrast with the 5th resolution. We didn't even decide 1, 2, 3, 4 on any of those resolutions that we presented on. A 5th one appeared at the last minute and was changed in the course of, again, a 15-minute discussion. And talking about when you start to talk about this but not that in the course of a courtroom appearance, when you start to say, you can do a motion to transfer venue, you can do a motion for forum nonconvenience, you can do a motion to compel further with sanctions or without sanctions, how do you meet and confer? You start talking about you can't do a summary judgment motion. However, to do a summary judgment motion, you might have to do a motion to compel further. It's a very specific thing you need to know, and I've trained young attorneys on it. It's a very detailed point of law on burden shifting. All of a sudden, you are involving a non-lawyer in something that's incredibly precise, a lattice of laws that's designed to protect consumers from 17200 down to all the different areas of law that we heard many speakers present on. And if people had known that our default position was full in-court representation, I can guarantee you that those discussions would have been different. So when it comes down to that, I changed my position and really think that people say, and they've said, in the context of consumer debt, enforcement judgment, these kinds of things, someone is better than nothing. Someone is better than nothing standing next to you. I don't agree with that. In these substantive areas where we have a wealth of laws in California, some of the best in the nation for consumer protection, they are not simple. One wrong ruling can affect millions of California consumers. In court, in my view, that default in this area is a terrible precedent. There's nothing worse that this committee can do than send non-lawyers into court on civil issues in any level. Nobody's done it but Utah in small claims only. Nobody's even considering it. And I really think this is the wrong way for this committee to go at this point.
I'd like to say I agree with a lot of what Carolyn just said. And I reiterate, personally, I think this one is a very close call whether to include in the program. What I would say is, we listed summary judgment and anti-SLAPP motions. What we've been told, and I'd love to hear from the judges on this, is that limited jurisdiction collection actions are very light on law and motion, and that it's really about, is there going to be a default or not? Is there going to be a motion to set aside a default? And then a lot of times, if the debtor has any counsel or puts up any resistance, the case goes away. So I would like to hear from the judges on that. But I would say in terms of motions, I personally wanted to avoid going through the entire code of civil procedure and saying, yes, you can do this motion, no, you can't do that motion. And so in my mind, substantive motions was left deliberately vague. But I have reasons, and I can get into it. I don't think it's necessary why summary judgment and anti-SLAPP motions specifically needed to be excluded.
Can I jump in here, Steve? You have two
Yeah.
other committee members who've had their hands up.
I'm sorry, I didn't see, go ahead.
Yeah, so I'd like to say something. I know Iris had his hand up and Judge Rubin had his hand up. So I was unable to attend all of the meetings because I had court considerations and requirements that which prevented me from going there. But I would have not excluded bench trials for many reasons that we've already discussed. I think paraprofessionals would have been fine to be able to handle bench trials, and I would have been more inclusive than the resolutions that we see in the report. However, I see this as we're building hopefully a ship or a rocket ship or something that will hopefully take off and stay in the air. And there's lots of people kind of trying to keep it on the ground. So I've been willing to compromise so that we can move forward. And with that said, I'll support the resolutions that are stated in the report.
Thanks. And then we have Ira and then Judge Rubin.
Well, actually, hold on a second, Leah. Erica, would you like to address at all some of the concerns that either Carolyn or Stephen raised about the appropriateness of representation for these kinds of cases?
No, in the interest of time, because I have to leave in 40 minutes, so I want to try to get to the employment issue. So
understood. Judge Rubin?
Oh, I was just going to address Mr. Fleischman's question about whether or not these kind of traditional limited jurisdiction consumer debt proceedings are light on substantive motions and motions for summary judgment? And the answer is yes. I think that he's accurately described, at least in the practice in San Diego County, how they come to us. I did them for a year and a half and did many, many of them. And I think the added benefit of having a paraprofessional of some kind in the room can also make those cases go away quickly. And just in terms of being able to talk to the attorney from the other side out in the hallway in a way that someone who's self-represented just is not in a position to do for a variety of reasons.
Ira?
There are many non-attorneys watching this meeting, and I just want to make it clear, it's clear to me that I can't see any way that a decision in a California state trial court could affect anybody but the litigants, the parties in the case, and could not possibly affect hundreds or thousands or whatever it is of other people in the state. You can't even cite the decisions of those courts. I'm done.
Okay, so in addition to these issues, the subcommittee also addressed wage garnishment, utility shutoffs, and enforcement of judgments. You want to run through those, Steve?
Yeah, wage garnishment was another close one, but ultimately we decided that it was complex and we wanted to exclude it. Steve, I believe it was Steve Hamilton brought up that we need to include it in the family law area in terms of enforcement of family law judgments. And there may be some inconsistency here on wage garnishment in the enforcement of judgments practice area, and the subcommittee may revisit that issue in the future. Utility shutoffs, Leah interviewed somebody at an agency that provides help. The consensus was almost all utility shutoffs involved less than $500. And therefore, we just really didn't see a market to hire a paraprofessional where the consumer would be better off hiring a paraprofessional rather than simply paying off the utility. And enforcement of judgments, here again, it's limited to natural persons, enforcement of small claims judgments, and limited jurisdiction post-judgment proceedings. Again, the same sort of common elements as other areas.
Are there questions or comments about what is up on this page? Ira?
Yeah, sorry for raising my hand so much. On wage garnishments, I think they should be included in all areas. And here's why I say it. I think they should be included for those paraprofessionals who have a JD, maybe an LLM also. They have the same education as a lawyer. And same education as a lawyer right out of law school anyway. In fact, they would have more because they'd have to have 500 hours of experience in the wage garnishment field. And so even though it's true, there's a good deal of complication in wage garnishment, but somebody who graduated law school can handle it.
Well, and I will just chime in on that point to say that I mean, I appreciate the point that you're raising, Ira, but I will say that I personally do not think we would be well positioned to start divvying up tasks between the paraprofessionals who have JDs and the paraprofessionals who do not. We're then, further complicating the system and putting in place really, a different set of rules for the different groups. Whereas I think, especially with rolling out a new program, my personal view would be that we should be consistent. You are a paraprofessional, whatever name we come up with at the end of the day, for a particular subject matter area, and this is what you're allowed to do. But that's just my personal view. Anyone else wish to be heard on this page? I don't see any hands.
Do we have resolutions to vote on?
Yeah, so let me stop screen sharing and let Linda talk about the resolutions.
I'm sorry, I've been having some technical difficulties, but I think I've resolved them. Can you see that now?
Yes, could you make it a little bit bigger, Linda?
Yes, and I put all the, oops, sorry. I put all the resolutions on one page. Can you see that?
Yes. Obviously, this is open for discussion.
Justice Fitzgerald, this is Judge Rubin. In line
Yes.
2, it says resolved, and the line underneath that, I'm wondering, would it be a little more crisp if we instead of saying but for the following excluded activities, we just said except for :
Yes. Oh, can't see that. So I hate to put the fly in the ointment on this, but I will say I don't know what substantive motions means. And I am concerned about that.
That was my attempt to try to avoid going through the Code of Civil Procedure one by one and identifying every motion. If I was in error, I admit it.
No, I'm not trying to point the error finger anywhere. But I'm just concerned with whatever we put out has to be something that someone knows what it means. And so, for example, if I'm a judge and I've been told that someone can't do substantive motions, what does that mean? You know, as we discussed in the subgroup meeting, I think, for example, the setting aside defaults important that someone be allowed to do.
Yes. Would Your Honor be?
Is it a?
Go ahead. What about substituting the word dispositive for substantive?
That's what I was about to say.
Okay. I accept that friendly amendment. Carolyn?
That proves my point, Your Honor. That's, you know, this is fraught with peril, because what's dispositive versus what's substantive. We're trying, if we want to get this to work, I don't know why we have to complicate all the other areas we're discussing. That was my point exactly, and I'll just step back.
Well, no, but you say complicated. How do you suggest, I mean, is your suggestion for not complicating it simply that they can't do it?
No, my suggestion is this all, if this was worthy of discussion, we should have been doing it for 10 months. To now come in and say, well, it's not substantive, it's anti-SLAPP. Does anybody know what SLAPP stands for? I barely do. There's no way to do this in court, Your Honor. That's my position. You throw it into court, and all of a sudden you have the lack of clarity. You have no bright lines, no bright rules. The legislative history will be tortured beyond words.
Sharon?
I agree with Carolyn. This is making my stomach turn. We don't have a lot of clarity in this, and I don't feel so comfortable personally resolving any of these at this point.
So when you say any of these, can I take one at a time here? For example, well, maybe I shouldn't be the one to do it because I'm not chairing the group. I'm wondering if there's some way to break this out rather than having 5 resolutions.
We could vote on them individually, and we could vote and see where the votes fall.
Let me ask the question of Judge Yu and of Judge Harper and of Judge Rubin. I would like to hear your views on that first portion of it and whether excluding dispositive motions is sufficiently clear or not.
Mike,
I don't quite understand the question. In
So the
terms of the
question-
wording of it?
Yeah, we're trying to understand whether, so I raised the issue that where it said substantive motions, to me, that was not sufficiently clear. I, as a judge, if I were sitting in the trial court and someone would said, this person can't handle substantive motions, I'm not sure what that means. I personally think I know what dispositive motions means. However, I would like to have the benefit of everyone, but in particular the committee members who sit on the bench, to understand whether this provides sufficient clarity or not.
This is Judge Rubin personally. I think I would know what a dispositive motion is. I understand Ms. Shining's and Ms. Bashan's concerns are, well, you might, but the Court of Appeal, unless we're more clear, the Court of Appeal will be the last word. But I think dispositive is actually a term of art, and I think I understand it.
And this is Judge Harper. I agree. I have a sense for what that would be before me to be able to handle that matter.
I was going to chime in that I would as well.
Hi, Professor Wilson.
And so I leave it up to the committee heads or to Leah as far as whether to try to go through this, how to go through this.
Yeah, I think we should see if we can get a motion and a second for the first resolution on individual debtors in limited jurisdiction consumer debt proceedings.
I move to adopt the first resolution.
Okay, do we have a second?
Second, Dana.
Okay, Linda, can you call the roll?
Yes, hold on one second, sorry. So it was Fleischman it was a Fleischman's motion, and who was the second? I'm sorry.
Dana McCray.
Okay. Bashan,
No.
Brynelson,
Yes.
Helmuth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer. Maybe Kim had to leave. McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarouche,
Yes.
Spyro.
Yes.
Claudia is still not here. Judge Wiley. Judge Wiley, are you still here?
I don't think she's here right now.
Okay. Judge Yu,
Yes, thank you, Linda.
the motion carries.
Can we move on to the second resolution?
I make a motion that we approve the second resolution.
And to be clear, the second resolution is the one that's is in regards to creditor harassment activities, specifically that pre-litigation cease and desist and prove up be included, that pre-litigation negotiation of settlements, including payment plans, be included, and that all superior court litigation be excluded. Does anyone wish to be heard on that? Okay, and then I'm sorry, was there a second on that one?
Second, Dana.
Thank you, Dana.
Okay. Sorry. So this was the same, I'm sorry, I'm just trying to manage the technical stuff here. So that was again, Fleischman moved and McRae.
Yes, it was the same.
Okay, all right, Bashan,
No.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Abstain.
and Judge Wiley, Judge Yu.
Yes, thanks, Linda.
Thank you.
Right, so we can move on to wage garnishment.
I move to adopt it, but I want everyone to understand at our next subcommittee meeting, we may be revisiting it. But at this time, I'd move to adopt it.
And adopting the exclusion of wage garnishment other than in the family law practice area, correct?
Yes.
And Dana, are you seconding this one as well?
No.
Okay, do we have a second for this one?
I'll second it, Judge Harper.
May I ask a point of clarification to Mr. Fleischman, Justice Patru?
Go ahead.
When you say you're going to revisit it, what does that mean to us, the consumer?
We have a meeting coming up next month, I believe. And I believe it may have been Leah. I don't remember who, but someone pointed out the potential inconsistency between the third resolution and the fifth resolution. And that may require revisiting the wage garnishment issue to make them consistent.
Okay, but it doesn't sound like it's going to change it substantively, just it's going to be calibrated so that they'll agree.
That is my intent as of today, yes.
All right, thank you.
So we have a motion and a second. Any other discussion, or should Linda take the vote?
Okay. Can I make a counter? Does Robert's Rules of Order let me table this one? Move to table it? No, probably not, but
I don't believe so, but someone can correct me.
I don't.
I also wanted to suggest that, I mean, I would rather see the final version and vote on that rather than vote on this and wait, see how you're gonna revise it.
So
So,
why don't we hear from Stephen Fleischman, whose motion this is, as to whether he's willing to do that?
I'm happy to remove this resolution and deal with it later if people want to vote on it all at once. My recommendation then would be to remove the fifth resolution as well, and that we vote on them in tandem next time.
I'm sorry, when you were referring to the fifth, which one is that, just so we are clear?
The last one regarding enforcement of small claims judgments
Right.
and natural persons.
Okay, so let's hold on the wage garnishment and on the last one. And would you like to move resolution number 4, that utility shutoffs for non-payment of utility services be excluded except in landlord-tenant disputes?
Yes, so moved.
And is there a second for that?
Ruben.
That was Judge Rubin. And conversation?
This is Elizabeth. The only thing I would add before you move it for 0.5 regarding the enforcement of small claims court judgments, do we need to just put enforcement and collection of small claims judgments, just to clarify?
I'm sorry, my brain froze for a second. I thought we were talking about a different resolution right now.
We are, I think, Justice Patru, that Ms. Olvera was saying that while she understands that we're removing 3 and 5 from consideration today, that when we get back to 5, we need to add the words "and collection" in front of the word "of" before the word "small."
Okay, so let's hold on that for a second, though. Is there any further discussion regarding the utility shutoff resolution?
I have a question. Is this being recommended for exclusion simply because you heard that they're largely under $500?
In my mind, yes. I don't want to speak for other committee members.
It just doesn't make sense to me. If a paraprofessional is helping with some of these other areas, but they can't call the utility company and try to negotiate because it's a small amount, I think we should leave that to the paraprofessional.
So can I ask a question, Ms. McCray? Are you thinking that they might be doing something else and then the utility issue is attendant to that and then they'd be hamstrung because they're free to do all the other stuff and then they can't call the utility company?
Yes.
That is something we didn't think about, at least when I was in the meeting. I don't recall that being raised.
I think we did think about it. That's why there's an exception for landlord-tenant disputes, for example, in the resolution. But I would say, in addition to the $500, is also the fact that PERM for publicly traded utilities provides this service free of charge. Now, it doesn't do it for municipal utilities. So that's an additional component. The low dollar value, the availability of the service for publicly traded utilities, which does cover a significant part of the state, and then the exclusion for the landlord-tenant sort of habitability issues.
This is Judge Rubin. I think this may be getting to that place that we've been talking about where this may not be an exactly perfect fit, but it's covers 95% of the cases. And as this evolves, again, depending on what form it takes when it gets enacted, we may see that this is a bigger deal than it appeared at first blush.
Ira?
It just occurred in this moment that in number 2, the creditor harassment activities, the pre-litigation negotiation could involve a utility shutoff. It could be a utility where the bill is so that is. So I think that utilities ought to be along with what is it? Where is the thing? Yeah, landlord tenant ought to be an exception in this.
So Ira, are you, or Mr. Spiro, are you?
Yeah, Ira's fine.
Are you saying that where it says except in landlord-tenant disputes, you would also add except in landlord-tenant landlord-tenant and or creditor harassment disputes?
Yes.
If that's a friendly amendment, I would, as a second, I would take it. I don't know about the mover, but.
Fine by me.
Judge Yu?
Okay, so I was going to use the same example as Ira, where I thought if the paraprofessionals writing to all these creditors and the litigants feeling harassed, but the paraprofessionals telling the creditors, look, my client doesn't have any money. Do you want to try to resolve this? And one of the creditors is the utility. I was thinking we should include that to go to Ms. McCray's point. But Ira did raise it and it is now in the resolution. I wonder if Ms. McCray is thinking that that covers it or if there's any other concern.
I feel better about it. I guess I'm wondering what is the risk to including it in the program? And it's just feeling like a little bit deep in the weeds.
Okay, I don't know that we had a first or a second.
We did. The first was Steve Fleischman and the second was Judge Rubin.
Okay, so does someone want to propose a substitute motion and we could see if Steve accepts it? Do we want to vote on it as it is and see where we are? Judge, your hand, is that a new hand?
Yeah, thanks. A new hand. I wasn't sure if we answered Ms. McCray's question though. She said she feels better, but she's not sure if it covers everything. And perhaps we can't cover everything, as Judge Rubin said. But I'm just wondering, because I'm so sorry, I'm at a disadvantage. I wasn't able to go to every meeting, so I'm not sure exactly how deep that discussion was.
Steve Fleischman, do you wish to respond?
No, it wasn't a deep conversation. It was, there are free services available in many circumstances, and the amount in controversy is typically very low. So we didn't see any benefit. My response is, this is a pilot program. It's going to evolve over time. And once it's up and running, if Paraprofessional Working Group 2.0 decides they want to expand utility shutoffs into the program, I'm not going to lose any sleep over it one way or the other.
Okay, I think we should call a vote.
Okay, Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
No.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Abstain. I wasn't here for the discussion.
McRae,
No.
Olvera,
No.
Robinson,
Yes.
Judge Rubin, Judge Rubin?
I said yes.
Unmuted.
Sorry, maybe I was muted. Sorry.
Okay, that was a yes. Shining,
Yes, it was a yes.
thanks. Shining,
Abstain.
Sarush,
No.
Spyro,
Yes.
is Judge Wiley back?
No, she is not.
Okay, Judge Yu,
I want to say yes, but I'm concerned because, Julianne Felmuth said no, and I didn't hear her reason. I wasn't sure if there were some things that weren't addressed. So I'm not sure if discussion was completely had.
You won't, this is Judge Rubin. If you say no, it won't offend me.
Julianne, what was your reason?
My reason is I don't think we should exclude these non-payment of utility shutoff from this program. I think that should be up to the client. If they want to spend their money to assist them in this area, I think they ought to be able to. And also, this is one of these unlawful detainer type massive tsunami issues that's going to hit very soon. Once all, and I just feel like this is an area that paraprofessionals can be helpful in, and they ought to be able to if the client wants them to.
Elizabeth has her hand up, and I'm going to vote no. Thank you, Linda.
And this is Elizabeth. I just wanted to give my reasons as well. I am fortunate enough to never have had my lights turned off, but it's something that's real for people. And it goes to, if your water's cut off, you cannot make food. If your heat's cut off, you're cold at night. And it goes to the very basic needs of people and the people who were looking to help through this program. So that's why I voted no.
I'm sorry, but I'd like to change my vote to no.
Fariba?
I just want to say we've been talking about access to justice. This is access to services. And I wasn't quite satisfied with the explanation I heard. I felt it was an artificial line. And I agree with everyone who said the paraprofessional client should make the decisions. Thank you.
With the further explanation too, this is Nicole. I'd like to change mine as well.
So I don't think we can do this the way that we're doing it. I think there's been further conversation that's been had, and the vote needs to be retaken from scratch as opposed to individuals popping up and changing their votes. If there's any other discussion or anyone wishes to be heard before the vote is taken, and understanding that once the vote is taken, we're not going to have further discussion in the middle of it. Let's hear from you now. Carolyn?
Oh, I just wanted to say I'm abstaining because I just think we're going to revisit it. It's going to come up again, and I'd rather not do it twice. That's all.
Okay, anyone? Erica, you have your hand up.
Yeah, I just want to apologize that I tanked this whole process. Didn't mean to, and I'm so sorry.
And if I can say something too, with Julianne's making that point that it's going to change with, the eviction moratorium expiring and everything like that, other issues are going to arise. And I had thought about that until she pointed that out. So.
Exactly. And so if anyone else wants to be heard on this, they're certainly welcome to speak up.
Yeah.
Ira?
I think it's not just the there'll be a lot of these utility problems, not just because of lots of evictions starting up, but because a lot of creditors will start to try to collect after the COVID emergency is done.
So let me ask the chairs of this committee whether they want us to take another vote, not another, that last vote was scratched and doesn't count. Whether they want us to take a vote on this at this time or wish to take it back to their committee. And Judge Yu?
I wanted to say that some of our colleagues don't say things as often as others, but I hope you know that your voices are really important to me, and I'm very persuaded by what Julianne said and Elizabeth and others. So I'm encouraging that people to sort of speak up, even if they haven't done so in the past.
Exactly. Second that. I second that motion.
Justice Petru, this is Judge Rubin. Who is the chair? I'm sorry, I probably should know this. Who's the chair of this sub?
The chair's Carolyn. And it sounds like this motion would not pass. And
it was very close before, so I don't know for certain.
Right, and given how close it is, and I understand that there are going to be times that we take close votes, but given how close it is, I think it is worth some further discussion within the subcommittee, unless Steve Fleischman, who sponsoring this motion, would like a vote to be taken.
Mr. Fleischman.
I have a question for the judges.
I didn't say, Mr. Fleischman, this is your second. I would suggest we send this one back.
All right, let's send it back.
All right. But what's your question for the judges? I always love to chat.
Is it true in Judges College, sometimes they tell you they teach you it's more important to make a decision than what the decision is?
I don't remember that. I think what they told us was once you've made your decision, move on. I mean, but if you think you're wrong and someone brings you new law, don't be afraid to go back and reflect on it.
Okay.
And if they taught us that, then they'd be teaching us to make a decision, any decision, even the wrong decision. So they try to teach us to make the right decision.
Yeah.
But I will say to make a decision, right? Because just sitting on things endlessly doesn't really get us anywhere, which is not what I think what we're doing here. No, okay, so that is.
This one's this one. People brought up legitimate thing.
Exactly.
Think the idea that we are about to have, we're about to tilt up the courts in the next 8-12 weeks, and that it's going to be. I hadn't thought about that. This is going to be a tidal wave of this. We probably should look at it through that lens.
Okay, and just so that I understand, Steve Fleischman, I believe you had said that it made sense to put off the last resolution. Could you explain to me why that is?
Because of the interaction between the last resolution and the third resolution vis-a-vis wage garnishment. In other words, if you're going to be allowed to enforce small claims judgments, then you need to have the tool of wage garnishment.
Okay. All right. Well, then let's table those further discussion by the subcommittee to bring back to us. Judge Yu, I know we're losing you very shortly, but if you could spend any time with us on employment, I think that would be helpful.
Sure. I wanted to lead off by thanking Leah and staff. We heard from a lot of people, and Leah was really working hard to get them to come. And some of them she had hoped to bring and they weren't able to make it. We have our resolutions, and I'm going to ask if we can put them up, but I also want to apologize that I have to leave at 3. I'm the judge presiding over a calendar where it's our case conference. And so I've got lawyers and justice partners logging in to Teams in 3 minutes at 3 o'clock. I guess I would just then hand it to you, Justice Petru, once the resolutions are up to take us through the discussion. Okay. Thank you, Linda.
Thank you.
Is it able, can you make it a little bit bigger?
Yes.
Okay, thank you.
And do you want to spend 3 minutes, Erica, telling us why you're in support of this resolution?
Yes. So some of what the first resolution really was made because we found that paraprofessionals could already represent people in Sorry, I'm having trouble reading it because it's so small. There we go. Thank you. So I tried to approach it as taking the low hanging fruit first. And so the first resolution with respect to Division of Labor Standards Enforcement Wage and Hour proceedings, we found that a lot of these proceedings are ones where people could help people and represent them anyway. So we didn't see a reason to bar paraprofessionals from doing that. Sorry, I only have 2 minutes. Basically, is this let's see.
Oh, I'm sorry.
I'm thinking of the 5 that we had initially. That is the final resolution, but we had the 5 initially that kind of went through each one. Thanks.
I apologize. I seem to have not created the right one for this one.
That's okay. It was just the
just
5
give
in
me
the memo.
Yeah, I'll bring that up
Okay, thanks.
in a moment.
On page 4.
Yes.
You had the right ones because you had the final ones. But I was sort of going to go by each of the 5 that we had initially.
Right. I'm just bringing it up now. I apologize.
That's okay. Don't worry.
I've been having technical difficulties today.
It's not, don't apologize. Thank you, Linda. While she's doing that, if I could just sort of say,
Please.
Thank you.
Yeah.
Okay, so the first one you'll see out of the 5 is that, or basically the first 4, and then the 5th one is kind of the final resolution. Initially we said paraprofessionals should be authorized to represent claimants, and we wanted to make sure it was claimants in the Division of Labor and Standards Enforcement Proceedings, because people can already represent people there. So that was an easy one, and that passed unanimously. Then the next thing we tackled was whether or not paraprofessionals should be authorized to represent claimants in the enforcement of Dlse wage and hour judgments in limited Superior Court proceedings. And that passed. 1 person abstained because that person thought it should be not just in limited jurisdiction Superior Court proceedings. So we really drew a line between things that would be limited jurisdiction and then those which would be much more significant in terms of dollars. But part of that was because we had information that most of these claims are really smaller, and they're definitely within the limited jurisdiction dollar amount. Then the third resolution that we voted on was that paraprofessionals should be authorized to represent parties in the enforcement of Dlse wage and hour judgments in limited and unlimited jurisdiction Superior Court proceedings. That was the next thing we voted on. It did not pass. So basically it was the flip of the second. And then the 4th was paraprofessionals should be authorized to represent parties in wage and hour proceedings in limited jurisdiction Superior Court claims. And again, that didn't pass. So then what we were left with is what Linda had up, which is that the resolution was regarding income maintenance, and we had to amend a previous resolution that was adopted. And that was that the group recommends that paraprofessionals be authorized to provide full scope representation at state administrative agency level proceedings for wage and hour in the Division of Labor Standards and Enforcement, for unemployment insurance proceedings, the EDD department, and all proceedings related to public benefits. There was also a resolution that paraprofessionals should be authorized to represent claimants in the enforcement of these wage and hour judgments in limited jurisdiction. There was an effort by IRA to resolve that we could do more, but that motion that is the last thing written here under the alternative resolution died for lack of a second. I'm gonna leave any questions to Justice Petru and the committee. And I'm so sorry that I have to go and that we ran out of time.
Thank you, Erica.
Okay, thanks. Bye-bye.
And I just want to clarify. So the 4 votes that Judge Yu was referring to are listed here. They're in the actual agenda item. And then here you have the resolution. And just to quickly say that this is intended to also serve as a modification of a June 30th resolution of the working group to kind of clean up the language around administrative agency representation.
And so Leah, is this the only resolution that we're putting forward to the employment group today?
Yes, there are 2 resolutions, and then these 2 resolutions here came from the subcommittee, the full subcommittee, and then Ira had an alternate resolution.
Okay, but the first one to me reads like one. I just want to be clear. Are we putting this forward as one resolution with the 2 parts, or is it 2 separate resolutions? Because right now it says further resolved.
They're 2 separate resolutions.
Okay, then it shouldn't say further resolved, right? It should just say resolved. Because further resolved is a part 2 of the same resolution.
Okay.
And I just want to be clear what we're doing.
I'm not sure that's consistently how we've done it, but that's okay.
Okay, so let's hear from Ira, then Stephen, then Carolyn. And again, if there are people who we have not heard from as much who would like to be heard, please put your hand up.
Okay, should I go now?
Yes.
All right. First, my apology to Steve Fleischman and to everybody else. That was a rather gross mistake on my part. About a half an hour ago, the subcommittee did not authorize wage and hour in limited jurisdiction cases. An example of wishful thinking, I guess, on my part. But well, let's see. My alternate resolution relates so much to this, to the first one, that I feel like speaking on it, but if it's out of order, I'll wait.
So you can go ahead.
All right. The reasons, one of the biggest reasons, maybe the biggest reasons given by everybody in opposition to representation for wage and hour claims, representation of employees, claimants in wage and hour claims, is that there's supposedly plenty, they can always get a lawyer, almost always, I suppose, is the contention. I believe that's not, in my experience, that's not true. I talked to other people from it's not true. They often can, but in any event, my alternate resolution is designed to meet that. It says that paraprofessionals will be authorized to represent claimants in wage and hour litigation in the unlimited jurisdiction part of the Superior Court, but only after they, I'm paraphrasing, after they send the client to the organization to which nearly all lawyers who handle these cases belong and who've been very vocal in our meetings. That's the California Employment Lawyers Association. And the client must give a statement in writing to the paraprofessional that they were not able to find a lawyer in that group. Now, in case this looks like special legislation or something for a bar group, we could also add legal aid or whatever other organization might be available for representation. But that meets what I see as just about the only, there's 2 objectives. It meets the main objection to allowing paraprofessionals to represent in wage and hour. And the other objection is how complicated it is. Well, a lot of these paraprofessionals, once again, are going to be people with JDs, LLMs, and we heard testimony that at least one person who is the head of a clinic in one of the schools is able to train law students to do this. It's not the most complicated thing in the world. And after all, we're talking about claims only up to 25,000. Okay, thank you.
Stephen?
Yeah, I just want to say we spent more time in this subcommittee than I believe any other subcommittee, with the possible exception of regulation and licensing. We heard from dozens and dozens of attorneys. The evidence on whether there are cases that are too small for lawyers to take in light of the ability to recover statutory fees is mixed at best. And while I have tremendous respect for CELA, and I think they're fierce advocates, I don't think we should be getting into endorsing any particular bar organization, no matter how well we think of them. And I think this gets into, I think, what Fariba said earlier, which is we don't want to start getting to a point where we're telling the potential clients not to hire a paraprofessional. You know, again, this is a first step. It's a pilot program. If it takes off and it's doing well, we want to expand to limited jurisdiction wage and hour cases, maybe. I still would like to see data, and it just isn't in the Justice Gap study report that people try to find lawyers and can't find them. So that's what went into these recommendations. And, you know, at some point I'll move to adopt the first two resolutions, but obviously we want to give people a chance to be heard further.
Right. Thank you, Stephen. Carolyn?
Okay. And just, I think it was Judge, other people have said, if there are people on this group that haven't felt the, you know, if there are too many lawyers talking or too many of us talking, please, 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 I want to hear from you as well. I just wanted to echo, I was the no vote, I was the nay on these, on the 4 different things. Our meeting was April 19th is the date of this, memo, but our meeting was after March 26th, if I'm correct. And so we understood, I think, that the default position is a certain way. And so there may have been things in my mind that came out differently had these things been the way we were going with our discussions in the group. And that really changed my mind. So I don't know what proceedings, and one thing that has never been discussed to my satisfaction has been, how do we prevent any attorney-client privilege issues in unlimited if these things get escalated or removed or moved? How does this talk to and approach the case law, which discusses whether or not these conversations and all these things are privileged? So yeah, those are my reasons, the same reasons as before when I changed my vote on consumer law, but I think I've been really consistent on this. And a lot of it is because of that change in our default position. Now we have all kinds of uncertainties in what this means. Yeah, that's it.
Thank you, Carolyn. Does anyone else wish to be heard? Stephen, your hand's still up, but I'm not sure if that's for comment or for when you want to move. Okay, I'm not seeing any hands. So Stephen, do you want to move on the first one, which is the resolution that CPPWG amend the resolution regarding income maintenance to allow for full scope representation at the state administrative agency level in wage and hour proceedings before the Dlse, unemployment insurance proceedings before the Employment Development Department, and proceedings relating to public benefits?
Yes, so moved.
And is there a second for that?
I'll second.
I'm sorry, who was that?
Dana.
Thank you. It's hard without being able to see everyone at the same time up at the top of the screen. Linda, do you want to take it away?
Yes. Bashan,
Yes.
Brynelson. Julia, are you here? I think Julia might have had to leave. Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hardston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro.
Yes.
And I think that's all of the people who are here.
Okay.
The motion carries.
All right, and then Mr. Fleischman, are you also moving where it says further resolved? that
So
legal-
moved.
Yes, okay, and so that is to authorize the representation of claimants in the enforcement of Dlse Division of Labor Standards Enforcement, wage and hour judgments in limited jurisdiction Superior Court proceedings. Is there a second for that one?
I'll second it, Judge Harper.
Okay, Judge Harper is the second, so Linda, you can take the vote.
Bashan,
Linda, I'm sorry, this is Brady Dewar from OGC. I just noticed that for consistency's sake, we might want to phrase this as a recommendation by the working group rather than, as it currently reads, it says paraprofessionals will be authorized, whereas we're really recommending that they be authorized.
I think that's right.
I
Offer that as a friendly amendment.
accepted.
And so it should read the further resolved that the CPPWG recommend that legal paraprofessionals be authorized. Is that correct?
Correct.
okay, I have that language.
All right, so with that language, and I presume the second, Judge Harper, you're fine with that as well?
I am, yes. Yes.
Okay,
Bashan,
Yes.
Brenelson, Felmuth,
Yes.
Fleischman,
Yes.
Hamilton,
Abstain, I had to step away.
Judge Harper,
Yes.
Hardston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro.
Yes.
I think that is all of the people who are here. The motion carries.
okay, so I'm not sure what to do. Ira, you have an alternate resolution. Would you like to move for that and seek a second?
Yeah, it really is an additional, not alternate. That's my mistake. Yeah, I move that what's called an alternate resolution. Okay.
Or we can call it an additional resolution.
Yeah. Anyway, I move the bottom paragraph.
And that would be that the paraprofessionals be authorized to represent claimants in wage and hour claims in limited jurisdiction cases, but not in PAGA, class action, or representative actions. And as you explained before, after the advisement to seek a lawyer and receiving confirmation that the client did so, but was unable to do so. Is that correct?
Yes.
All right. So I guess the question is, since I don't first or second, whether there is a second.
I can second it, but I did have a question about the California Employer Law Association. Can we also put or through the Bar Association of their county? Would that help?
I'd like to address that. The problem with that is that that's a much more limited group of attorneys to seek a lawyer from, and the California Employment Lawyers Association is a really big group to seek it from.
I understand, and I second it as is.
All right, then Linda, you can take the vote.
Okay, Bashan,
Oh, I'm sorry, I need to disclose, I'm a member of California Employment Lawyers Association, although the association and I have been at odds over most of
Thank you for that disclosure. Okay, with that and not seeing any further discussion, Linda, you can go ahead and take the vote.
Okay, Bashan? Is Sharon here? Maybe Sharon left. Brynelson? Can you hear me?
Julia,
Julie had to leave.
she let us
Okay.
know she was leaving.
Okay. Falmouth?
No, because I don't think we should be naming that association in a resolution.
Fleischman?
No, and I would add, everyone agrees these are incredibly complex cases.
Okay, can we, and I don't mean to cut people off, but when I ask if there's discussion, that's the moment to say whether there's discussion and comments that wish to be made. If we need to open discussion back up, someone tell me so, and otherwise, let's just please vote yes, no, or abstain.
Hamilton?
No.
Judge Harper?
No.
Artston?
No.
Kirkmeyer?
No.
McRae?
No.
Olvera?
Abstain.
Robinson?
Abstain.
Judge Rubin?
No.
Shining?
No.
Sarouche?
No.
Spyro?
Yes.
And that is the balance of people who are in attendance. The motion does not carry.
May I just
All
add
right.
one thing that I am not a candidate to get, I would not have been a candidate to get cases through the Employment Lawyers Association under this resolution because I don't take litigation anymore.
I think we all, I will speak on behalf of myself, although I think I speak on behalf of everyone, that we know that your suggestions and considerations are all heartfelt and towards the benefit of the general public and not your potential individual benefit. I think that's quite clear.
Thank you.
Okay, so let's now at this juncture, Linda, if you could please close, or Leah, if you could close your screen, and Linda, if we could please take further public comment. I see there are 2 hands up.
Yes, the first is the phone number 2500.
Good afternoon. Can you hear me?
Yes.
Good afternoon. My name is Clemente Franco. I'm an attorney, and I'm not like the other speakers. I'm not a leader of the private bar. I'm not a certified professional. I'm a decent attorney, I believe. But what I do bring to the table is my history and my experience and what I serve, the community I serve. And that is that I am the first generation son of immigrants, undocumented immigrants at that. I was born and raised in South Central LA, and I've seen the damage that these paraprofessionals, because we've had them for a long time. The Business and Profession Code allows for unlawful detainer assistance and it allows for immigration consultants. And I am constantly picking up the pieces of cases that have been damaged by these individuals, lives that have been ruined. The state already allows immigration consultants, so I think we can look to that as the future of these programs. And I think we're doing a disservice to the public by allowing these individuals to, in essence, practice law, something we wouldn't allow a recent law graduate. I commend you for trying to address the problem. I think we do have a problem. It's a big problem when people who want to do public interest law get out of law school with
30 seconds
150,
remaining.
200 dead, and they can't do it. But as someone whose family has been impacted by these individuals, although I think the die is cast and the deal is done, I would urge you not to allow this. And if so, let me know where I can lay the cases that are going to be ruined and the lives that are going to be ruined by these acts. Thank you very much.
Angela Grijalva.
Good afternoon. Thank you guys for taking my public comment. I wanted to say thank you to Elizabeth Olvera, especially, and her comments about and to keeping the group focused towards the basic point of this whole profession is to serve the underserved, and speaking and keeping an eye towards basic needs, basic necessities. I appreciate the large in-depth conversation that's happening, but I always think it's important for us to get grounded. And even while these aren't necessarily our firsthand experiences, basic necessities such as water, utilities, I think that's important. One of the things I also think it's important to understand about the community I represent, the undocumented, while I'm not a member of them, and while the Latinas are not a monolith, but for the most part, the Latina community doesn't speak out and doesn't seek services. So in terms of creating another profession, and one of the reasons why is because they're intimidated, afraid of, and they have been burned by attorneys in the past, and so they won't go there. So I think opening up these other alternative paraprofessional is important for the Latina community because it's less intimidating. And as a legal document assistant, I can tell you that I have helped
30 seconds remaining.
Swaths of undocumented community members successfully. And that's my comment. And I'm sorry that the other speaker had that experience. Perhaps he can start training and helping and reaching out to those members.
Melissa Grant.
Yes, hi. I'm Melissa Grant. I'm a partner at Capstone Law. I've been doing wage and hour cases for more than a decade. My greatest concern with the first resolution that you passed is a client or a claimant needs to know and get legal advice as to whether or not they should bring a claim in court or bring a claim before the Dlse. There are very serious issues to address, whether they should bring it as a class action, whether it should be a PAGA action, whether they should just go it alone before the Dlse. There is case law that talks about Berman hearings and their limitations, but a paraprofessional cannot provide that legal advice. So the resolution is starting in the middle of the story. And I am concerned for claimants for that reason. There are other concerns I have, but I'm going to address myself only to the first resolution that you passed. I think the same can be said for the second as well. But I strongly feel you're starting in the middle of when an employee or needs legal advice. Thank you for hearing me.
Linda, I don't see any other hands, do you?
No.
All right, so if we could please move into family.
Yes.
All right, thank you very much. So I have our recommendations organized in 3 segments, and we will put up the resolution after I'm done going over each segment unless there are any objections. And I invite my my committee members to please chime in as needed. First I want to discuss family law, violence prevention, and adoption. Our family law, yes, Judge, Justice Petra.
So I think that we just had another hand go up, and I'd like to just have the opportunity for public comment quickly. If Linda, if we could, you can leave the screen up, but if you could let Ms. Carol Peters be heard, and then we'll continue. Sorry, Fariba.
No problem.
Okay, go ahead, Ms. Peters.
Hello, thank you very much. Carol Peters, elder law attorney for more than 40 years. I have 2 questions, 2 comments. One is the pre-contract discussion is absolutely critical. And my experience is that
either the elder person or the family members are usually asking me the wrong question. And I would expect that to continue with the paraprofessional, because people do not know the law and they do not know what they need to know. The second issue about the access to justice, I am wondering if the bar might be able to set up a system similar to the MCLE reporting, where we can report the pro bono hours that many of us provide for the various nonprofit groups where we serve on boards and provide other services to the community. Thank you for your time.
Thank you very much. Okay, Fariba, back to you.
All right. So as far as the topic of family law is concerned, we had a list of recommendations back in December, and they're the same. Pretty much we're excluding complex issues, and I'm hoping that you all have looked at the list, and if you have any questions, please tell us. But basically, the common theme here is if there's anything too complicated in terms of issues, we have excluded them from the work that paraprofessionals will be authorized to do in the area of family law. For example, marital settlement agreements, or Marvin actions, or nullity actions, Hague actions, and so on. With regards to violence prevention, we actually kind of went back and heard from subject matter experts regarding different types of violence prevention causes of action. So there's domestic violence, or case type, sorry. There's domestic violence, there is civil harassment, workplace violence, gun violence, and we heard from subject matter and elder abuse. We heard from subject matter experts on elder abuse and workplace violence, and the recommendation was basically to include them. All across the board, these types of restraining orders are paper intensive. There are judicial counsel forms for every one of them, and it basically litigants need assistance with filling them out, make sure the declarations are relevant, and all the information is presented in a fashion where a judge can read and understand and be put in their position to be able to make a decision regarding their request. And of course, on the response side as well, to help with the responsive forms. So our recommendation is that paraprofessionals be allowed to help with all types of violence prevention paperwork. With regards to adoptions, we heard from our own Elizabeth Alvera. This is step-parent adoption. And then also staff spoke with Robert Walms. He is from the Academy of California Adoption Lawyers. And again, because these types of adoption are very form intensive, there are judicial counsel forms for these types of adoptions. The recommendation is that paraprofessionals be allowed to assist with uncontested step-parent adoptions. And at this point, I believe we have a resolution. If you could put that up, then maybe the resolution regarding family law, violence prevention, and adoption. And let's see, Judge Rubin, you have a question.
I do. Thank you for calling on me. The reason that, and I just need a little explanation here. The reason that we are putting the modification of uncontested step-parent adoption versus uncontested adoption is that the uncontested adoptions are that are not step-parent, you are saying are too complicated?
You know, I actually, this was so long ago, I do not remember why we left out regular adoptions, and I wanted to see if any of the committee members remember that.
My question wasn't meant, and it's not rhetorical, because I've done the uncontested adoption calendar, and it seems pretty pro forma, but I have to admit that I'm on the consuming side of it and everything's done already. But so I was just curious because it didn't, anyway.
That's a good question. I want to see if committee members remember our discussion with regards to regular adoptions and why we left them out.
Regular uncontested adoptions,
Or
right?
sorry, regular uncontested adoptions, Your Honor.
I think the discussion started with
the input that we got from Mr. Walmsley, that was not during a meeting.
Mhm.
And I think it had to do with the home study issues and other factors, was my understanding. I don't do anything other than step parent adoptions. I think that's why the distinction was made. You can bypass home studies in a step parent adoption. They're a much different proceeding. It's basically replacing a non-parent with someone who's been acting as a de facto parent. I think that was the rationale, that they're much more complex cases and you've got to deal with the adoption agencies. And I think ACAL was very assertive about that would not be an appropriate area for a paraprofessional to take lead responsibility on.
And I guess because also you'd have to run through there's also involvement of the dependency courts. So that would,
Right.
all right.
Yeah. Steve?
Yeah.
Sorry.
Where did you guys come out on trials? As I understand from the memo, you're allowing bench trials, but I didn't see that in attachment A or B to the memo. And then a follow-up is same question regarding depositions and expert discovery.
So I think there are two parts to your question, if I'm understanding it correctly. The first part being in-court representation.
Yes.
And we haven't had a chance to discuss in-court representation, and we're leaving that out of our recommendations today.
Could I just make a comment on that for the regulations subcommittee? I didn't understand why the rule on trial publicity was taken out of the rules. If we're going to allow paraprofessionals to do trials in family law, I think we need that rule. Go ahead, Fariba.
Okay, so the second part of your question had to do with discovery. And if you look at our list for family law, we have discovery as a separate segment, and you'll see what's included and what's excluded.
Could we see attachment A, since we're talking about that? I mean, we're talking about what they may assist with, and the resolution is that they may assist with family law, violence prevention, and adoption tasks included in attachment A.
Yes, I'll bring that up to share.
And Steve, could you repeat your specific question regarding discovery?
I had understood depositions and expert discovery were to be excluded. Steve Hamilton at another meeting told me that may be in play. So I'm trying to figure out, are those in or are they out?
No, they're out.
I would be in favor of them being out. Okay.
So maybe we could, would members want us to go through the attachment item by item? I just did, for sake of time, I thought everybody's gotten it, everybody's looked over it. If anybody has any questions, we can address them, but I'm happy to go over them.
I don't think we need to go over them. I just think it's good to have it up, and if people have specific questions.
Okay. Amos,
Can you see it now?
Yes.
Yes.
Yes, it's up. Amos?
Yes, I do have a couple of specific questions on attachment A. One is expert discovery. So I understand, I'm not a family law practitioner, but I understand it's fairly common to require like a forensic accountant or someone like that in order to really understand what's going on and what the assets are, even though it's not necessarily a overly complicated case. If expert discovery is excluded, would that exclude the use of professionals like that?
So Stephen Hamilton is our litigator, so I'm going to ask him to answer your question.
I don't think that it would, Amos. I think that they would be a consultant that somebody would talk to, but if it didn't result in a resolution and it was necessary to conduct expert testimony because somebody served a demand for exchange of expert witness exchange, that's when it would have to shift over to an attorney.
This is also Judge Rubin. I don't know if Mr. Hamilton agrees with you or not, but in the cases where I've had that happen, they're pretty resourced cases, and I don't think we would be dealing with paraprofessionals in any event.
Correct.
Right. And the very first step is to do a preliminary declaration of disclosures, and those are just pretty routine, and paraprofessionals are authorized to do those.
You're not getting through trial with a forensic accountant, even if it's just tracing issues. By the time you get them through trial, the bill is going to be at least $20,000.
Got it. Okay, very helpful. And another exclusion for settlement agreements. So it seems like there's a premarital, postmarital agreements not including MSAs that are excluded. And I just want to make sure that doesn't exclude the ability to do, settlement agreements.
No, they get to do settlement agreements, but it has to be disclosed in the settlement agreement that the agreement was prepared and or reviewed by a paraprofessional.
Great, thank you.
And the premarital, postmarital agreements are highly regulated and highly complex. And not even all family law attorneys do those. It's very hard to get one hold up at the solution.
I remember the Massey prenup. That's how specialized it is.
Yeah. All right. Any other questions on these? All right. So for family law violence prevention adoption, we have a resolution that if Linda could put those
Yes,
up.
go back to the resolutions.
Point of order, I don't think as a chair I can make a motion, yeah? Or can I?
I think you can, but
Yes, you
someone-
can.
Well, I'll say that I move that we adopt the resolution on the screen with regards
I
to
second.
specific attachment A as to the duties that can be performed by paraprofessionals.
And just to be clear, Stephen, are you moving everything that's on this page or just the first paragraph?
Let's do it as one. See if anybody's got an issue.
Okay, so just the first paragraph. And do we have a second for that?
I second it.
Okay, and how about just further discussion?
Oh, I saw one. Oh, Carolyn, Shiny.
Yeah, I just wanted to know again, there was a part, oh, why am I freezing? Okay. There was a part in here again that says that you did not consider the March 26th full in court in this memo at least. Was there discussion of that?
We don't have a recommendation on in-court representation. We haven't had a chance to discuss that. So we're leaving in-court representation, fee caps, and guardianships for another meeting, for our next group meeting. Do you still have a question, Carolyn? You look a little puzzled. Or it could be Zoomitis, I don't know.
There's a bit of that. It's a lot to grasp in 15 minutes worth of time.
Okay, and then Judge Harper and then Amos again.
On the violence prevention, is that both parties can be represented by paraprofessionals? Doesn't matter what side they're on?
That's correct.
Okay, great. That's all I had. Thanks.
Amos?
Thank you. I just want to clarify if the motion is for the first paragraph only or for
It
both.
is I clarified that, Amos. I asked and the answer was first paragraph only. And I do want to say, I appreciate, the fact that we're on limited time, but I also appreciate the fact that these resolutions and attachments are sent out, with a good amount of time before the meetings. And so it does require time outside of the meeting. We just can't get around it. There's no way to do that.
Mm-hmm.
Further comments? I'm trying to look for hands.
Actually, let me, before Carolyn, I'll let you ask your question is, I'm not sure why we are doing just the first one, because the second one, I just noticed what you meant. The second one, it just recommends the adoption of educational training requirements. And I'm not sure why we're separating them. Stephen?
Say that one.
So why are we separating these two in terms of?
I didn't mean to. I meant as one thing. I apologize.
Okay.
It wasn't worth going back and clarifying.
Okay.
No, let's see.
So I'll move again that we adopt paragraph 2 that's on the screen right now, that we will adopt the educational and training requirements for these topics as set forth in attachment A.
And to be clear, Stephen, you are making one motion to adopt everything that's on the page, both paragraphs.
Absolutely.
Mm-hmm.
And I'm sorry, I just want to make clear that if there's a second for that.
Yes, I
And
second.
Farida has a second. Carolyn.
Okay, I just wanted to just add again, the way we've done this upside down all of a sudden throws this all into all kinds of concerns to me. I'm all for favor of help in these areas. However, I have no idea how this is going to turn out at the end of the day when we throw in that full in court, half in court, all that kind of stuff. So I am inclined to vote no for those reasons.
So I appreciate, I guess I appreciate your confusion. I just don't understand it, because we're right now talking about outside of court assistance. And we're stopping at the point, because right now our group default position is to allow for full in-court representation and leaves it to the individual subcommittees to decide whether for that particular specialization, we're gonna go with the default or, pull back. We haven't had a chance to discuss. So if we go with your concern, that means we're gonna hold off on every recommendation that we have until we can come back with that recommendation included. Is that what you?
Yeah, I think that's the way we should have done it. I mean, I really think that if you had all these subject matter experts come in and you told them all, this is going to be full court representation. Now, what do you think about adoption tasks? I think you might have heard completely different things. So I think it put a huge wrench in all our 10 months worth of deliberations. So now you guys weren't as much, the family law group wasn't as much and as deep into it as some of our other summer deep dives. But I still, March 26th, we changed the whole entire direction of this working group. And it really, I feel very deeply about that.
Any other questions? All right.
I see a hand. Julianne?
Yeah, I just have a point of clarification. The resolution here, which I've never seen before, has 2 paragraphs and they both refer to attachment A. What I printed out here for today was an April 19th memorandum and then a February 26th memorandum, which has an attachment A and attachment B. And I might be missing this, but your second paragraph here refers to educational and training requirements. And I don't see those. What am I missing?
So there are, Stephen, please correct me if I'm wrong, there are footnotes.
Yeah.
On the bottom.
Yeah, within the attachment, it might be just either footnotes or within the definition or description of a particular task, the requirements were set forth.
I do think it is a correct point, though, that in the printouts that we were given, it is labeled attachment B.
Oh, okay.
Right, that's part of the reason I wanted to put up attachment A's. I just want us to be clear when people are moving or voting that we know what we're moving or voting on.
Mm-hmm.
So I think the first paragraph stays attachment A, right?
Yeah, first paragraph does not change.
I think actually the whole thing became attachment B in this version.
Okay, so we need to be very clear because
Yeah.
I'm not going to call for a vote without having complete clarity as to what people are voting on.
So in the agenda, so when it was put up in April, the tasks were attachment A, but in this version that was posted in for today's meeting, the February memo became attachment A, and the list was somewhat revised from February. So that's now attachment B. And so the resolution actually is for attachment B.
That's not gonna, I appreciate that, but that's not gonna work for me without actually seeing what we're talking about and making sure that the people making the motion are in agreement that we're talking about the right thing.
Okay, I can bring that up again.
Yeah, the attachment I got on April 14th was still labeled attachment A. That's why I'm now confused.
Mine too.
Attachment A for most of these subcommittee memos is the last action of the subcommittee. So it's a prior memo. So attachment A is now just simply the prior memo, which has an attachment. Yeah.
Yeah, and the prior memo still has an attachment A. So attached, which is, I'm sure, is what's causing the confusion. Whereas today's memo also, let me bring that up, has an attachment B. Hold on.
She's doing that. I'll just say on page 2 of the.
So this is what it is. This is attachment B. So the attachment A that has the list is actually the attachment A from the February memo. This is the attachment B from today's memo.
All right, we need to take a moment to look at this and make sure that the committee members, subcommittee members have had a chance to look at this and confirm that this is the latest version that they intend to be attached to their motion. So hold on a second so it can be read. It's too much to go through that fast. So once the people moving have had a chance to look at this page, let me know.
I wanted to point out there were a couple of, oh yeah, the in-court representation is not. It specifies on this one that it's a split recommendation, and that's one of the things that differs from the attachment A that was included in the February memo.
Where is that on here?
I can show you that. Under child welfare.
I can't, yeah, just.
I'm sorry, here it is. So under child welfare, there's a split recommendation for in-court representation. Oh, that's actually, we're not on that one yet. So
No,
we're just,
we're just
okay.
on the family law.
Right, family and adoption.
Family law, adoption, and violence prevention.
Violence prevention.
And on neither of those, we
Right.
have a recommendation regarding in-court representation.
So do you want me to go back to where near the top? Or are people reading their printed version?
Right, I'm fine. Steve has a chance to.
Amos has had his hand up for a while. I don't know.
Oh, Emma, sorry.
No, it's okay. We were letting people take a look at this, so it's fine.
Yes, and I think you may have just clarified this, but attachment B does include child welfare, and my understanding is that is not included.
Right. And thank you, Amos. I was about to jump in and say the same thing. This is giving, this is problematic for me because I was unclear with the exhibit A versus B, and now I'm seeing that exhibit B actually includes more than you intend to be included with your motion.
Well, so the motion specifically says the family law, violence prevention, and adoption tasks included in attachment B.
Okay, and then where is the language or where's the reference regarding the educational requirements?
The footnote. So you go back, down right there. And we just kind of refer down here with regards to the special educational requirements we're recommending.
So I'm sorry. So
I apologize. I'm just a little confused. So
yeah, I am too,
please
Nicole.
forgive.
So for example, it's hard to make sense of it while looking at this right now. So for example, where it says if instruction includes detailed in-depth education regarding family code, and then it goes through.
Can I make a suggestion to the chair?
Yes.
We've got 9 minutes until this meeting finishes. I'm not comfortable with the confusion that the memo in its current format's creating, that we should be taking a vote on this today.
On any of it or just the education piece?
I think everything. I think there's us creating a clear record for everybody and them having an intelligent ability to vote on our proposals. I don't think that can occur. We can't clear this up in 9 minutes.
And I have no problems with that. If we could, like last time, we also got ready to present and we didn't get a chance because there's so much to discuss, very important. And perhaps, we can get a 2-hour meeting or something like that to vote on this, or next time, like get our own time frame, because we keep getting ready and not going forward. And I will make sure that the recommendations are set up in a way that's not confusing.
Okay, let me hear from Julianne and Stephen, please.
Thank you. Yeah, I think this should be sent back for a rewrite. You do have a fairly clear expression of your educational training requirements for violence prevention, which is at the bottom of page 3 of attachment A. But for example, under also attachment A, the first task, dissolution, domestic partnerships, under number 3 there, you have something that's excluded, excuse me, annulment based on incest, unsound mind, blah, blah, blah. Why would you have special educational requirements for something that's excluded, which you seem to have here? So I think you just need to rewrite or redo the attachments.
Stephen?
I was just going to say the same thing. Let's table this for now, come back with a clean motion. I'd really like to vote on housing, if possible, in the next 7 minutes.
I doubt it, but we can certainly start the conversation and see. And, you know, if people are willing to stay a little bit past 4, in order to make that happen, we'll see where we are. So why don't we let's just start the conversation on housing and see where we are. And who's leading this discussion?
I guess I'll lead this discussion. This is Mike. So Linda, why don't you go ahead and just put the resolutions up? I think that'll help guide the discussion.
Okay, I will do so.
Thank you. So before she gets those up, just obviously a big part of our, if you've looked at the material, a big part of our discussion regarding housing and landlord-tenant issues has to revolve around the right to counsel efforts in California. And so there's an effort right now. There's, I think, 3 counties right now that we know that there's some type of program, San Francisco, LA, and Alameda. They all have programs that provide free representation to tenants in landlord-tenant disputes. There's an effort for the whole state to have that same type of representation. We want to make it clear we are in full support of that, and we don't want to compete with that in any way. We don't think of this as a competition, but as a supplement to that, or in addition to that, in those areas where people may not qualify for that free representation. We also expanded it to landlords, and there is a need for low-income landlords to have representation as well. We did speak to a judge in Alameda County. He said almost all of their tenants are represented, but in Alameda, a significant amount of their landlords are not. And he felt that the program could help landlords in that area. I know from my experience up here, very few of our landlords are represented. And so we have basically 2 unrepresented parties in court on landlord-tenant disputes. So, but in terms of the right to counsel movement or effort, we want to make sure we support that 100%. And so you'll see that reflected in these resolutions that we've put forward today. But we do think that there is a need for the paraprofessionals to help in this area. And so that's again reflected in what we're doing. And I see Steve's got his hand up. Steve?
Stephen
Did you have a chance to read the memo I circulated over the weekend, Judge Harper?
I did not, no, sorry.
Essentially what I'm saying is, while I understand there may be low-income landlords, why are we making the cost of legal services less for landlords while we're about to have a tsunami of unlawful detainer cases where most landlords are able to afford attorneys? And that if there's a need for low-income landlords, what I suggested, and I'm not tied to the number, but why not allow representation of landlords with less than 5 residential units, or 10 or 20 or some number? I mean, I'm sympathetic to the mom and pop that have a guest house in the back and they need to get their tenant out. Okay, I get that scenario, but the largest residential landlord in LA County is a very wealthy husband and wife who operate through a DBA. So I don't know why we need to be helping them with cheaper legal services. So that was sort of my recommendation, was to take everything you're doing, but just sort of limit it on the landlord side. And then I wanted to clarify that we're only talking about residential unlawful detainers, not commercial.
Right.
I mean, that's implied in the word housing, but.
Yeah, that's my understanding, but I'll let Ira and then Fariba. Ira?
Yes, I agree with Steve Fleischman about the landlord thing. I wanted to add to it that I think that the limit on landlords should be that they only own one property. with up to, I'd propose 6 units. All right, and then I wanted to add that I had other proposals they're in a report. There's 2 of them, but they're pretty much the same. I think, well, I'm persuaded that allowing paraprofessionals in counties where there's a realistic possibility of a right to counsel movement too seriously will interfere with the efforts to establish right to counsel movements in those counties. It's almost all, it's just the large counties, not even all of them. And so I think that we should restrict paraprofessionals from those counties, and they're to be named later, but I named a few of them in a proposal I have.
Reba?
Just wanted to remind you, another group of landlords we help here at the Self-Help Center are sublessors and people who let a friend stay on their couch and that they won't leave, and also parents who have children who are disturbing their peace and doesn't rise to the level of a restraining order, but they need help to evict. And we help landlords here, but for example, one line we've drawn is multiple units. We don't help with that, definitely not commercial landlords, but there are a lot of people that we help in those categories.
And I don't have a problem with Steve's recommendations either. I don't know what the number would be, but I think to limit that down to restrict it to people who really need the services and not people who could take advantage of the services, I think would be important.
Yeah, I mean, I think we can all agree, certainly, like if someone has someone living in their own home that they need to evict, that may be the kind of person who should qualify for this kind of help.
Trying to see where that would fit in on the resolution. We could say.
You want me to add the word residential in front of landlord tenant?
That'd be helpful, I think.
Yes.
Judge Hartford, I would suggest just the first bullet point, limited to representation of tenants and landlords who own less than 5 residential units. And again, I'm not tied to the number.
Sure, and I don't have a problem with that.
Or what Justice Petra says, which is landlords, somehow we think of the language, but limit to landlords who have let somebody stay at their house or sublease or something, tenants who sublease or something like that. I'm not even allowed for anyone with multiple units.
Well, we have people who own homes who they use that rent to pay for that mortgage for that. So when they, so they can't afford an attorney, yet they do own a unit and they're using that income to pay for that unit. So I think we see a lot of that up here where landlords can't afford an attorney and they do own a unit or 2 or 3, but they can't afford to hire an attorney. So I think the 5 units doesn't offend me.
But how do we choose 5 and not 4 and not 6?
I agree. It's a random number. I agree.
It's very arbitrary.
It's not very arbitrary, it's extremely arbitrary.
Yeah.
I mean, I made it because I can count it on one hand. I mean, that's it. I mean, I can see arguments for a lower number. I can see arguments for a higher number.
Well, I can see an argument, honestly, I can see an argument for 2, which would limit you to either you have someone in your own home or you simply have a second place. And that's it.
I'm fine with 2.
I'm fine with 2 as well. Ira?
I think that the change is probably better up in the opening paragraph where it says assist clients instead of clients, and we say tenants and then our landlords with the limit on it.
When you say 2 units, do you mean 2 rental units? So that would it or does the 2 units include the unit that the landlord is living in?
I was thinking of including.
I
because
think-
you're still renting, whether, it's, I mean, I guess part of the issue becomes how do you define a rental unit? So I don't know if we need to further clarify to say, to represent landlords who are seeking, I'm trying to think who here is a housing expert and can put the right verbiage on this. Because, yeah, Ira.
I think units is a pretty well-recognized term in landlord-tenant law. So I think it's okay.
Would it
So the
include, though,
landlord-
Ira,
if
if
the
someone
landlord
rented out,
lives- I'm sorry.
would it include someone renting out a room in their house, though? Would that be a unit?
Well, we're saying up to 2, there might be no units, but.
Right.
Right.
Okay.
But does that mean if someone lives in a house and owns separate from the house they live in, they own 2 rental units, that's okay?
Yes.
That's included, okay. Okay.
May I bring up a comment? I'm just not seeing it, and it probably has already been discussed, like squatters.
The squatters, the landlords are going to have to go through a eviction process for squatters anyway. So I think this would allow a landlord who couldn't afford an attorney, who could afford a paraprofessional to get rid of a squatter.
I
Only
have a
if they have-
question for,
All right, I was gonna say only if they have squatters and 2 or fewer units.
Sure.
Yeah.
Judge Harper.
Yes.
I thought the idea about mandatory settlement conferences was great. My only question for the judges is that going to put a strain on judicial resources? Is that going to cause delay? I just want to hear a judicial officer say that's okay.
I think it's okay. I mean, obviously, once someone does a demand for trial in an unlawful detainer action, there's 21 days. So the idea was to try to force some sort of discussion between a paraprofessional and whoever's on the other side prior to that day and for the trial, because there's usually not a date between that. So we're trying to recommend a rule of court that will require in unlawful detainer cases that pre-trial day for settlement. And I think that would be actually more efficient and it'd be better for judicial economy than actually hurt judicial economy.
Okay.
It's mainly for the parties to get together to just talk. I mean, it's kind of like a meet and confer, but because that time frame's so tight, you really can't build that into the 21 days until trial.
Okay.
Other than a mandatory conference. But yeah, it might cause a little, some calendars to grow a little bit, but I think in the long run, it will save that trial date. You're basically going to move one date to another.
I agree.
So on that first resolution, we've got that representative limited to tenants and landlords shall no more than 2 units. Is everybody okay with that?
I am.
Okay. Does anybody want to make a motion regarding that?
Just, could you repeat the rationale for that,
For the 2 units?
for the 2 units?
I don't really have a rationale for it.
I just
I'm the
want
one
to
who
stay away from
suggested it.
the arbitrary, that's all.
Farida, I was the one who suggested it.
Uh-huh.
And my only suggestion was that my thought was we wanted to limit it to people who have a real financial need. And that if someone has someone in their home or maybe has one other unit that they're, supporting with that seemed like a reasonable limit. That is just to me. I'm not moving, I'm not voting unless there's a tie. But to me, it seemed less arbitrary to cap it very low as opposed to starting to cap it between the numbers 3, 4, 5, 6, 7, 8. Someone who really has multiple units out there. But again, it's not my motion.
I move that we adopt all the resolutions.
Do we have a second?
Are you raising your hand or are you seconding?
Secondly,
Can I just clarify because this alternative resolution?
No, alternative is not part of it. No.
Okay, got it.
So any further discussion on the resolutions that are on the page other than?
Who made the motion?
Fleischman.
Okay. And Judge Harper, you seconded?
No, Ira did.
Okay.
And then we have a couple of hands raised, Carolyn and then Sharon.
I just have the same full in court representation problem I've had all day. That's all.
Well, the problem is because if you have an attorney on one side and they know the paraprofessional cannot try or we're not saying they can try the case, but if they know that they're gonna have to drop out of the case, they only have 21 days. There's not enough time for that tenant to get an attorney. And so it'll become a strategical point for an attorney to force through a trial, knowing that a paraprofessional, so at least the paraprofessional can be with their client in court to be able to answer any questions from a judge. So I think the first speaker we had today, Jason Solomon, he said, this isn't about having an attorney on top of the paraprofessional, it's about them representing themselves. So we'd rather have a paraprofessional with them in court than themselves. So that was the justification for that.
Yeah, and I think in my dissent in the consumer debt, I said someone is not always better than nothing. But I see your point, Your Honor.
Sharon?
If I want to go about voting for the alternative resolution, how do I do that?
Once we get through this, if we do, then I will see if Ira still wishes to move on the alternative and whether there is a second. And if so, we'll take a vote.
Thank you.
And Carolyn, is that your hand raised again, or is that the same hand raise? Okay. Is there any further discussion? Kimberly?
Sorry, I just have to add this. The last resolution there, about the requiring a settlement, I know we chatted a little bit about it, but I just don't know that it fits here with what we're trying to do. That might be something that should happen, but is it really have anything to do with the paraprofessional program, or is this just an overall change that you're recommending in a process? Sorry, I'm not familiar enough with the type of law.
That's a good point, Kimberly.
So it's an overall change. So when in an unlawful detainer case, the law requires that once a demand for trial is filed with the court, then it has to be tried within 21 days from that date. And so typically, I know in our county, and I can't speak for all counties, but typically the only date that's set is a trial date. So you don't have any time to discuss that matter. So
Michael, this is Joanna. Let me just jump in on that. I think the issue is not, does this make sense? Or would this be a logical thing to do? Or would we like to see this happen? Because I think most of us would like to see this happen. The question is whether this is outside of our purview to be able to recommend a change to how unlawful detainer cases are handled in the courts, as opposed to the role of the paraprofessional in doing so. If Greg is still online, I would like to hear from him on that.
And I'd also like to speak to it, if possible.
Your Honor, it does seem to be a bit outside the scope of what we're being asked to do here. I mean, without a little bit more, I don't know if I can give as much of an informed opinion as you may want, but it strikes me as being a bit outside the scope.
Well, I mean, and I don't know if there's a way to modify to basically say we would like to transmit, that basically that we would like to share some way to share our view that a settlement conference, would be a good idea.
And I think that was our intent. It just, in the form we have here, the resolution is how we were going to do that. Amos, I know you wanted to talk.
Yeah, so at least at the subcommittee, the way this was discussed, it was definitely related to the paraprofessionals and making it more effective, because the idea was paraprofessionals were going to be able to assist clients in pre-litigation or non-trial context, and settlement discussions are a big part of that in UD cases.
Sure.
Settlement discussions during the court date when trial is about to happen, very different dynamic than if there could be settlement discussions previously to that trial date. So we did discuss it in the context of making the paraprofessional program more effective and efficient, both for litigants and the court and paraprofessionals. And that's why I think it does fit in with these recommendations because it's directly related to.
I understand that. I just don't know that, I mean, we're certainly not doing it with other areas. And again, I understand the thought behind it, but I don't know that we should be going with suggested changes to the rules of court that change the actual procedure for how, for example, a family law case is heard or unlawful detainer case is heard. Because, for example, I don't think that we should be voting on these resolutions, presuming that that's going to be part of what happens, because we don't know if it will.
Carolyn?
Oh, yes, Your Honor. I just thought of something when, I hate it when this happens, but was any consideration thought through with regard to cases where there are mold and you know, unlawful detainers happen because when people don't have livable units and apartments. And then, so before the trial is held, I think what you do is you can file a cause of action against the landlord for uninhabitability considerations. And that seems to, I think, put the brakes on things. So would a paraprofessional be informed and given the advice and be able to do that kind of thing?
My understanding, and I'll let the chair speak, but I've listened to a lot of these meetings and that has certainly been discussed at some length.
Yeah, absolutely. Yeah, no, that was contemplated and that's part of this. Yeah. Fariba and then Ira.
Just real quick on the settlement conference, you have to say that issue is being discussed by a legal services agency in our county and our court. And I know that there's significant resource issue, but this program is being launched in 2023. So I don't know what the resources are going to look like then, but I do think it's outside of our scope. So I would just not vote for that piece of it.
Ira?
It occurs to me that we could express our opinion on something that's outside of our scope. And I also wanted to make it clear that the reason, Ines is right about the reason for it, but to be more specific, it's almost impossible to get in most places, most cases, to get a landlord to even talk to the plaintiffs, the tenants' lawyers before the trial date. It's
Right.
impossible to get negotiations. So this is one way to help bring about and to make the paraprofessionals work more effective, a lot more, I think. We could say, for instance, that we urge that mandatory settlement conferences happen because it'll make the paraprofessionals work a lot more effective.
Okay, does anyone have an amendment, or does the person moving this want to either drop the last thing or modify it in such a way that it's a recommendation from us as opposed to our, I'm just personally somewhat uncomfortable with our proposing changes to the actual protocol for how cases are handled. I think that's outside the scope of our mission. And I think if we start doing it in this area, we're going to then start doing it in other areas. I don't see it.
So should we just drop it or can we say further recommended?
Well, it's up to you. So let's see,
Well,
something like.
it's not my motion.
Well, further resolve that the California Paraprofessional Program Working Group recommends settlement conferences in each unlawful, I don't know. I don't know.
Justice Petro, it's my motion, and in the interest of taking the issue just off the table, I'm happy to drop that paragraph from the motion.
And I will say that if the group wants to come back with some suggested language for us to consider, because I would like to be able to transmit this thought that it is would be very beneficial, period, full stop. Honestly, whether a paraprofessional is involved or not, it would be beneficial, but we'll drop it from this motion. So, and the second is fine with that as well.
It was Ira.
Who's the second? Yes. Okay, so Ira gave a thumbs up. All right, so with the deletion of that final paragraph, I think we're ready to take a vote.
Bashan,
Yes.
Falmouth,
Yes.
Eichmann,
Yes.
Hamilton. Hamilton?
I think we lost him, Linda.
Oh, okay. Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
He had to leave.
okay. Shining,
Can't hear you, Carolyn.
Abstain.
Sarush,
Yes.
Spiro.
Yes.
The motion carries.
Okay, and with that, Ira, do you still wish to propose an alternative resolution?
In the interest of time, no.
Okay, all right, then thank you to everyone for staying the 15 minutes over. I appreciate it very much. I know it's especially hard on a Monday like this. And I know people have other meetings that they needed to get to or go to, but again, it was a very interesting and I think very productive at the end of the day conversation. I really appreciate people piping up when they're unclear about something. I mean, some of these issues don't come to light until we're actually looking at it, okay? And so we'll come back on the one that we couldn't get to today. Let me talk to Leah and Linda and also the chairs of the group about a separate meeting, and if so, when and how that would play into the subcommittee itself. So we'll have that conversation offline and then circle back with everyone. And I hope this is the start to a great week for everybody.
Thanks, everyone.
Thank
you.
you.
Bye.
Bye.